I get a lot of comments about whether or not NYSRPA versus Bruen signed off on all shall issue permitting regimes. In other words, how is it that the Supreme Court said in NYSRPA versus Bruen that licensing requirements are okay? But did they really? Let's talk about this. We have to be nuanced on this one. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for Frederick Douglass, who came up with the first three boxes of American liberty in the 19th century. Okay, folks, I get this question a lot, and I want to walk you through it. A lot of people in the Second Amendment community are bothered by the fact that if you read NYSRPA versus Bruen, the Supreme Court's decision, it seems to be suggesting that permitting of the Second Amendment or licensing regimes to allow you to carry guns outside the home in public for self-defense, which is a constitutional right, is improper, and the Supreme Court should not have signed off on these licensing regimes. Well, it's not clear that they actually approved all licensing regimes. What they did was a little bit different, and I want to walk you through the nuances of the NYSRPA versus Bruen case so you really understand the geeky details of what the Supreme Court did and what it did not do, and why I think they wrote what they wrote about shall issue licensing regimes. Since the decision in Bruen, the anti-gunners have largely treated the Bruen case as proof that shall issue licensing regimes are constitutional. Now, as a reminder, before Bruen, you had three types of licensing regimes. You had permitless carry, places like Vermont where you could just carry because. That's obviously now the law in 26 states where you can just permitless carry a handgun without any kind of license or anything like that. Then you had shall issue, which was the law in about 43 states that said that as long as you met an objective, narrow criteria, you could carry guns outside the home with a license. And the last outlier jurisdictions, there was about 6 or 7 of these, depending on how you measured it, were the may issue permitting regimes that basically said that you had to go to the government and go, "Mother, may I carry a gun outside?" And these states, blessed you or not, basically treating the Second Amendment right to keep and bear arms as a privilege and not a fundamental constitutional right. The U.S. Supreme Court in NYSRPA versus Bruen struck down the may issue permitting regimes and said those are totally unacceptable when it comes to determine who is when it comes to who shows a specific need to carry a gun versus they just want a gun because they're Americans, they want to exercise self-defense. So that has now been solved. But in the context of writing this decision, there was a series of references both in the majority opinion by Clarence Thomas as well as in the concurrence by Brett Kavanaugh talking about shall issue permitting regimes and strongly suggesting that in their view, shall issue permitting regimes in and of themselves did not prove to be a constitutional problem unless they were abused. But did they really say that? Let's talk about it. Well, the first thing to understand is that in a Supreme Court decision or any opinion by a court, you have what's known as the holding, which is like the central decision that's actually the decision made. In the case of NYSRPA versus Bruen, the holding was that the right to bear arms means that we have a right to carry guns outside the home for the purposes of self-defense under the Second Amendment, and it's a fundamental right. On a related note, it also lays out as part of the holding the methodology that lower courts, also known under Article 3 of the U.S. Constitution as the inferior courts, are supposed to apply when they decide Second Amendment cases. Those were the holdings. With that said, if you probably noticed, the Supreme Court's decision ran on for dozens and dozens and dozens of pages. They talked about a lot of different issues. They talked about a lot of different arguments. They analyzed a lot of different history and so on and so on. The reason why I bring this up is because the rest of the opinion that's not specific to the holding or essential to the holding of the case is what is known as dicta, which just means it's there, it's insightful, it's helpful to understand, but it's not necessarily, the official rule of law by the U.S. Supreme Court. The reason why this distinction between the holding of a case is important versus the dicta of a case, specifically with NYSRPA versus Bruen, is because the discussion about whether or not shall issue permitting regimes all took place in the context of NYSRPA versus Bruen's dicta Meaning it was discussed, yes, but it wasn't part of the holding, which means technically speaking, it's not officially binding law. It's not the law of the land. It's simply important, valuable discussion, yes, but it's not the holding, which is the official ruling of the court. Now, we are not shocked by this because the reason why there was no really other way for the Supreme Court to handle this is because the question of whether or not a shall issue permitting regime was simply not before the Supreme Court in Bruen. Why do I say this? It's really quite simple. Think about it. In NYSRPA versus Bruen, the question presented to the court and to the judges was this: is New York's may issue permitting regime that says you can't have a gun outside the home for the purposes of self-defense or otherwise unless you show that you are special in some way, whether or not the may issue permitting regime is constitutional under the Second Amendment? The answer was no. Do you see what I just said, though? The may issue permitting regime was what was before the U.S. Supreme Court in Bruen. What was not before the Supreme Court in Bruen was, bing, 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 shall issue permitting regimes. Why? Because the New York state law being challenged was not a shall issue permitting regime. It was a may issue permitting regime. So the Supreme Court didn't even have really the legal authority to reach out and talk about shall issue permitting regimes as a matter of law because it wasn't in front of them, number one. Number two, the plaintiffs in this case, the NYSRPA plaintiffs and the individuals specifically stated at oral argument in Bruen that they were not in their legal challenge to the New York regime challenging or arguing whether or not the shall issue regimes in the other 43 states were constitutional. Let me just read you a little bit of the oral argument. Justice Kavanaugh at argument asked Paul Clement, the lawyer for the plaintiffs, Justice Kavanaugh asked the following question, quote, "But I understand you would not object or do not object to the regimes that are used in many of the other 42 states, the shall issue regimes. I mean, there could be particular problems with those, but I do not understand you to object to shall issue regimes here." Period, close quote. That's what Justice Kavanaugh asked the plaintiff's lawyer. He wanted to know, is this accurate? And what did the plaintiff's lawyer say? Mr. Clement, on behalf of the Second Amendment plaintiffs, he said, quote, "That's accurate, Justice Kavanaugh," period, close quote. So you see what happened here? So by virtue of Paul Clement's statement to Justice Kavanaugh that they're not challenging in Bruen the shall issue permitting regimes, the Supreme Court's like, okay, well, if you're not arguing it, you're not challenging it, you haven't briefed it, you're not fighting about it right here and right now, we, the Supreme Court, are not going to reach out and address some issues that are not before us because that's not what courts are supposed to do, especially the Supreme Court. They only want to deal with the issues presented to them in a particular case. Because shall issue regimes were not presented in Bruen, they did not deal with it, and that's the reality of it. Moreover, of course, Mr. Clement's arguments on behalf of his clients are not binding on future litigants. So if somebody else is challenging a shall issue permitting regime somewhere in America, that is not binding on them because they weren't in front of Bruen and they weren't represented by Mr. Clement. So Paul Clement can only bind, if anyone, his clients. He can't bind people that are not his clients, and that's just obvious. Moreover, the Supreme Court specifically said they weren't deciding shall issue permitting regimes in their opinion. This is what the Supreme Court wrote in its opinion about shall issue permitting regimes. They said, quote, "To be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes under which a general desire for self-defense is sufficient to obtain a permit." Now, this is significant. Keep in mind that the Supreme Court saying that nothing in their opinion should be taken as suggesting that shall issue permitting regimes are unconstitutional, again, is binding. That is dicta. They're making a reference to that. And specifically, though, keep this in mind, they did open up the door to possible challenges to shall issue regimes. And this is what the Supreme Court wrote, and I think this is telling. They say, of course, to the extent a shall issue regime contains only narrow, objective, and definite standards guiding licensing officials, that might make it okay. But then it goes on to say that, quote, "That said, because any permitting scheme can be put toward abusive ends, we, the Supreme Court, do not rule out constitutional challenges to shall-issue regimes where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. Now, you might say to me, Mark, okay, we understand that, but why did the Supreme Court feel the need to suggest that they were not knocking out or raising issues about shall-issue permitting regimes in Bruen? This is going to require you to get really geeky and to know some history of the Supreme Court and Ruth Bader Ginsburg, believe it or not, to really understand what I think the Supreme Court is doing here, because they play the long game. Keep in mind the Supreme Court only hears between 80 and 90 cases a year now, so they're very selective, and they pick and choose carefully those cases with the biggest bang for the buck. Now, I think that the Supreme Court is not touching shall-issue permitting regimes, and I think there's two reasons for this, and I'm guessing you're not going to hear this anywhere else but the Four Boxes Diner Second Amendment channel. The first is the Supreme Court is well aware of social trends when they're moving in a particular direction that's favorable to the Constitution, and they're well aware of the importance of the Supreme Court not doing anything unnecessarily abrupt, because they've learned from a prudential mistake that the U.S. Supreme Court made in the Roe versus Wade case. Specifically, and this is not any conservative attacking the Supreme Court over the Roe decision, this was none other than pro-abortion advocate and attorney and Supreme Court Justice Ruth Bader Ginsburg. You see, Ruth Bader Ginsburg thought the Supreme Court made a terrible mistake when they decided Roe v. Wade, and here is what she wrote about Roe v. Wade, and tell me, and then I'm going to explain to you why I think this is significant, and the Supreme Court has taken heed of this in the context of shall-issue permitting regimes in the context of the Second Amendment. This is what Judge Ginsburg said about the abortion decision Roe v. Wade in 1973. Quote, "Abortion law then was in a state of change across the nation." She goes on to say, "There was a marked trend," and this is key, start what I'm about to say, folks. Ruth Bader Ginsburg about abortion. Quote, "There was a marked trend in state legislatures toward liberalization of abortion statutes." She basically then went on to say that under those circumstances, the Supreme Court could have simply struck down the particular Texas statute that was an issue, instead of trying to fashion a regime blanketing the subject, a set of rules that displays virtually every state law then in force. In other words, Judge Ginsburg said, quote, "Roe v. Wade," and the Supreme Court's decision in Roe v. Wade, quote, "halted a political process that was moving in a reform direction and prolonged divisiveness and deferred stable settlement of the issue." Period, close quote. What I just said there by Ruth Bader Ginsburg is this. When Roe was decided, state legislatures were loosening up, liberalizing their abortion laws. That was the trend. But when the Supreme Court came out and just decided out of the blue that abortion was a right and all these abortion restrictions were unconstitutional, that caused, needless to say, a uproar that we've been dealing with ever since. Now, how does this relate to our Second Amendment rights specific to shall-issue carry regimes and challenges there too? I think what the Supreme Court is thinking is two things. One is they're reminded by what Ruth Bader Ginsburg said about Roe, and they're thinking to themselves, you know, we don't need to knock out all these shall-issue permitting regimes because guess what? The process in the states is in the process of doing our work for us. Because as of today, we now have 26 states that have permitless or constitutional carry that do not require a permit at all to carry. And there may be more states, specifically Nebraska may be coming down the pike, as well as North Carolina. So we may wake up very soon and find ourselves with 28 states moving in favor of the Second Amendment right to carry with permitless carry. Now, this is something the Supreme Court is probably looking at and realizing we don't necessarily need to step in to deal with this now, because just like abortion was liberalizing in 1973 when the Supreme Court just abruptly jumped into the issue, we, when it comes to shall issue carry regimes, which, by the way, this doesn't apply to other issues involving the Second Amendment, I'll get to that in a second, but when it comes to shall issue carry regimes, we, the Supreme Court, don't feel the need to get in because, frankly, the trend is in the process of solving the problem for us, so we don't need to inject ourselves just yet. I think the second thing going on is the Supreme Court has prudential concerns. Again, they only take 80 to 90 cases a year. Most of those cases cannot deal with the Second Amendment. They have tons of other problems and issues across the country they have to deal with, and only a limited amount of bandwidth. And I think when they look at the Second Amendment issues, what they're really signaling with saying we don't want to mess with shall issue regimes is we have bigger fish to fry in the short run. They're probably looking down the chessboard. I think probably a high likelihood next kind of case will, whether or not 18 to 20-year-olds are protected by the Second Amendment. I think that clearly the answer is yes. I think this is an easy case for them. I think, any kind of an AR-15 ban case is also an easy case for the Supreme Court. Again, by the principles of a fortiori, if you're going to protect all semi-automatic handguns, which was the Supreme Court said in Heller and Catano, I don't see how you reach a different conclusion with semi-automatic rifles. And by the way, Justice Kavanaugh in the Heller 2 case, when he was on the D.C. Court of Appeals, reached that same conclusion, saying that semi-automatic rifles were obviously protected under the Second Amendment. I think it's pretty clear you have 5 and likely 6 votes, maybe even more, but certainly 5 or you certainly have at least 6 votes to protect semi-automatic rifles if that case gets to the U.S. Supreme Court with the current Supreme Court composition. So bottom line is, I think that the Supreme Court, when it comes to the shall issue permanent regimes, indicated that they don't want to deal with this issue next. They got other Second Amendment issues they want to handle first before they get to a direct frontal assault on shall issue regimes, and they also can see the handwriting on the wall, which is these regimes are slowly but surely going by the wayside in favor of permitless carry regimes. And as you know, when every state that's ever gone to permitless carry, I'm not aware of a single one that has ever gone back to a permitting regime. So once you lock in a permitless carry regime in a particular state, doesn't appear to be any evidence that ever flips back the other way. It's like a one-way ratchet for freedom, as I like to say. So, okay, folks, hope you enjoyed this. If you haven't subscribed to the 4 Boxes Diner Second Amendment channel, please do so. We'll see you again here at the 4 Boxes Diner.
Orders up. Table 2A.